Well, courts are running out of money just like the rest of the government, folks. Only a matter of time before Hegseth and Kavanaugh are forced to switch back to canned beer. Happy Tuesday, everybody. I'm Bryno, and this is the morning report on the federal courts for October 21st, 2025. Double tap your screen, comment your go-to canned beverage, and watch through the first minute, even if you're bookmarking this for later. Check the link in my profile for ways to support me and keep this sustainable if you enjoy my work. Grab yourself a coffee, and let's get down to business. All right, we are going to start with a lighter one. We're going to look at afgE v. OPM, but actually nothing to do with the real case. A couple of days ago, there was a strange filing in this case, which is particularly interesting because this case is closed. And I don't want to come down on this filer too hard. It sounds like he's having a tough time anyway, but it seems like the judge noticed. So there are these, let's call them motions. And I've seen this document filed in a few different cases, but this judge actually decided to respond. They're not super coherent. They say something about a family law case in California, a missing car in North Carolina, and something about Ted Cruz. Beyond that, it's a little hard to follow. Now, I do understand that, among other things, this filer is asking for the return of his sacred thread, which I didn't know is something very important that marks the beginning of the spiritual journey, lifelong journey in Hinduism. It's a very important thing, but it's listed in the middle of a very long paragraph of other things which the writer has lost, including his house, his car keys, and his car. So, like I said, the case is fully closed at this point, and the judge was obviously surprised to see a filing in it, and clearly more surprised once he read it. But he took a moment to respond, saying, quote, "In this post-judgment matter, a third party, so not a member of the case, pleads for the return of sacred thread among other requests not always coherently stated, but which appear to have been denied in actions pending in other jurisdictions. All these requests for relief now being made to all judges and senators and others beside, this court lacks jurisdiction to consider any of these requests. The third-party filing is dismissed." End quote. Now, I hope the guy who filed this manages to get his car and sacred thread back, although it appears they've been lost since 2008, so I'm not super optimistic. I'm also not sure that a case about firing government employees was really the place to do this, but nevertheless, Godspeed. Okay, next we are going to head to Portland, where the Ninth Circuit approved a stay pending appeal in Portland and Oregon v. Trump. This case is incredibly confusing, so I'm going to do my best here. Work with me for a minute. Okay. In September, the president ordered the federalization and deployment of the Oregon National Guard in Oregon. Federalization means the president is in charge of those troops instead of the governor of Oregon. Deployment means they actually get put to work. A district court in Oregon issued a temporary restraining order blocking that presidential action. This is what we're calling TRO number 1. The president was blocked from federalizing and deploying Oregon National Guard troops in Oregon. I'm going to cut to the chase here. The decision yesterday that everyone is talking about was only about TRO number 1 because, according to the decision, the federal government has not appealed TRO number 2, which I'll tell you about in a second. But yesterday, the Ninth Circuit decided that temporarily, while it decides the appeal, it's going to pause TRO number 1. So, what about TRO number 2? Well, right after all this went down, the president said he was also going to send troops from Texas or California or somewhere else. And so the plaintiffs filed a second TRO, TRO number 2, to stop the president from deploying any National Guard members in the state of Oregon, including the Oregon National Guard. And this TRO was granted. Well, according to the opinion from the Ninth Circuit, the defendants have not appealed the second TRO. Now, in a footnote, footnote number 8, if anyone wants to look, it's in my shared documents under military. The court says that at oral argument, the government said that since both TROs were so similar, they assumed that if one was stayed, the other would be too. And in about the third to last paragraph of the main opinion, the court says that they agree. They never totally say, though, that TRO 2 has to be dissolved, and usually these things are made pretty explicit. So for those of you who are confused, join the club. At the end of the day, the Ninth Circuit mostly has allowed the president to federalize and maybe deploy the National Guard in Oregon. Technically, there's an argument that the second TRO still stops him from doing so, but it's unclear at absolute best. That said, the governor and AG of Oregon have called for a rehearing en banc at the Ninth Circuit, so who knows, it might get reheard. But let's talk about the decision itself for a minute. Now, I've read this decision. I don't think it's a great decision. It's actually mischaracterized some of the history that I happen to know pretty well, but as usual, until somebody gives me a black robe, my opinion is completely irrelevant. But the general idea is this. There are questions as to whether government property in and around Portland has been damaged, whether crowds in and around Portland have been unruly or peaceful, and whether federal officers have been allowed to do their jobs or prevented from doing them by local residents. And you or I may have an opinion, having seen things with our own eyes, as to whether or not those questions are answered in the negative or affirmative, yes or no. But from a legal standpoint, the important question here is about who gets to answer those questions. Who gets to decide, yes, people are acting badly, or no, people are not acting badly, and sending in the National Guard is a good idea or a bad idea. Because 4 out of 5 dentists may agree that Crest is good for your teeth, but if the 5th dentist is the one that RFK Jr. hires, then HHS is going to recommend we brush our teeth with ground whalebone or something. In other words, it doesn't matter whether, in your opinion or my opinion or in 95% of the world's opinion, it is reasonable to send in the National Guard. The real question is who the law says gets to make that decision. Is it the president or Congress or maybe the governor? But it's got to be somebody specific though, right? It can't just be, well, what does everybody think? Well, 2 of these 3 judges believed that Congress wrote this law so the president could decide. But that is not their final decision. This was just a stay. This was a quick flip through the law, and this is how they've decided it's best to leave things on pause while they do the real deep dive. But even if this decision is the one the Ninth Circuit ends up with, even if it's affirmed by the Supreme Court, all that means is they think this is how Congress meant the law to be read. So Congress can just change the law. That's it, quick and easy. This isn't a constitutional decision, it's an interpretation of statute. So, if you don't like it, elect new statute writers. That's the fix. There are 379 days to midterms. Pick a candidate or start your own campaign, but I'd probably get on that. Okay, last thing. We're going to talk one more time about Alina Habba because she was in front of the Third Circuit Court of Appeals yesterday defending her reappointment to the position of U.S. Attorney for the state of New Jersey. Now, normally, the president appoints someone to this position and they are confirmed by the Senate. But until that happens, the president can appoint an interim U.S. attorney for up to 120 days. And the rule under 28 U.S.C. 546D is that after 120 days, the district court can vote on appointing a replacement. So that's up to the judges in the district court. And we talked about John Bolton and his case because the Maryland district court judges voted to keep Trump's choice for interim attorney in place. They're allowed to do that. And it happens. But in New Jersey, it didn't happen. And the court discussed why a bit. Ms. Habba lacks experience, she's made some decisions that the judges haven't been happy with, etc. So, on July 22nd, 2025, the District Court of New Jersey voted, and they appointed Desiree Lee Grace as the new U.S. Attorney for the state of New Jersey. Well, the Trump administration immediately fired Ms. Grace and reappointed Alina Habba, a move which the Trump attorney in yesterday's hearing called, quote, consistent with long-standing practice, end quote. Well, let's say the judge was skeptical. Can you come up with an example of any time that such concatenation of events has occurred with respect to the appointment of a U.S. attorney? Asked the judge. Well, I guess I cannot, said the lawyer. So much for consistent with long-standing practice. The court did not issue an immediate opinion, but I will let you know when they do. All right, that is your Tuesday morning report on the past day in federal courts. Stay calm, everybody. We're going to be okay. Keep watching, and I will keep making these. Thanks a lot, and have a great Tuesday.